Warning, warning. While extremely important, the content in this video can also be extremely boring. Please do not watch while driving or operating heavy machinery. In fact, your best bet is to grab a glass of wine, slip into something comfortable, and lay down while watching. Thank you. A power of attorney, or POA, gives someone else authorization to handle certain matters, such as finances or healthcare, on your behalf. There are a few different types of POAs, which we'll cover here. However, I need to point out the obvious. I'm not an attorney, and I'm not providing legal advice. I'm far from an expert in these matters, but I have seen numerous scenarios throughout my career that make it an important subject to take a look at. Join me as we take a closer look. Hey everyone, I'm Bill Warrell, your Bradenton, Sarasota Realtor, and between my work as a banker, real estate agent, and as an independent notary public, I've come across many situations where a power of attorney was needed. Unfortunately, most instances were sad and upsetting, which is why we're doing this video. It's unfortunate because by the time most individuals learn about power of attorneys and the various types, it's often too late. Before digging into the types, let's dig in a little bit as to exactly what a power of attorney is. A power of attorney is a document made between two individuals, an agent, who is the individual who has the authority to act on behalf of another individual, called the principal. I used one when I moved to Florida and sold my home in Pennsylvania. I wasn't going to be around for the closing, so I authorized another individual to sign on my behalf. That part is easy. The harder, more confusing part is knowing which type of POA you need to ensure that you're fully protected. The state of Florida recognizes three types of powers of attorney: general power of attorney, a limited power of attorney, and a durable power of attorney. A general power of attorney covers a wide range of transactions such as buying and selling property, managing bank accounts, filing tax returns, or applying for government benefits. A limited power of attorney provides an individual the ability to act on one's behalf for certain types of transactions, or maybe for just a certain period of time. The general and limited power of attorneys expire if the person they represent becomes incapacitated. That's an important distinction because once the individual becomes incapacitated, they are not deemed mentally competent to enter into a power of attorney agreement. That's why it's so important to get this done before something happens. A durable power of attorney may be more appropriate because it remains intact even if a person suffers mental incapacity in the future. Durable powers of attorney help you plan for medical emergencies and declines in mental functioning and can ensure that your finances are taken care of. Having these documents in place helps eliminate confusion and uncertainty when family members have to make tough medical decisions. Florida law defines incapacitated as the inability of an individual to take those actions necessary to obtain, administer, and dispose of real and personal property, intangible property, business property, benefits, and income. Let me explain why this is so important. A while back, I was working at a bank when an individual came in to withdraw money from their grandfather's account. Apparently, the grandfather had suffered a heart attack and was confined to a hospital bed for a period of time. His wife had passed away and the bank account only had the grandfather's name on it. The grandson explained how his grandfather's bills were piling up and not being paid, yet nothing could be done because the individual, the grandson, had no authority to act on behalf of his grandfather. If you become incapacitated and don't have a durable power of attorney, your family may have to go to court and have you declared incompetent before you can take care of your finances. So it's a good idea to have one just in case. The agent, again, that's the individual who has the authority to act on behalf of another, can be whoever the principal wants, so long as both agree. I remember another instance not long ago when an attorney contacted me and asked me to meet him and his client in an assisted living facility. The client was laying in a bed, clearly not doing very well. The attorney explained the power of attorney to the man, who then asked who his power of attorney would be, to which the attorney answered, "Your son." The man's response was that he didn't trust his son to do what was in his best interest, and he refused to sign it. Eye-opening and sad in many ways. As a notary, I've always discussed POAs and wills together in the same conversation. While some POAs expire when an individual becomes incapacitated, all of them expire upon death. A will would appoint an individual as an executor who would facilitate the sale, disposal, and distribution of any of the individual's financial affairs upon their death. While a power of attorney is a valuable part of estate planning, once the individual passes away, the agent holds no power or authority for the individual. So if you're considering using a POA as part of medical or healthcare planning, it would be extremely wise and prudent to also include a will. POA and will forms can be do-it-yourself and found online. However, it's helpful to talk to an attorney about your estate planning needs so they can recommend the documents that will work best for your particular situation. Again, please don't misunderstand this to be legal or medical advice. This video is meant to serve as a simple explanation of POAs and wills along with their importance. Thanks for watching.